been a wonderful experience for me, and I enjoy doing what I do. And largely what I've been doing over those 20 years is helping boards of directors and homeowners and condominium associations navigate the difficulties that come with HOA issues, HOA law. So I'm excited today to talk to you and to discuss these issues. So let's jump in. First of all, it's always important to know your name. And so you will see in your governing documents, you will see in guidelines and rules, different names used covering architectural review. Three most common are the Architectural Control Committee, or ACC, the Architectural Review Committee, ARC, Design Review Committee, DRC. Those are the three over the past 20 years as I've been looking at documents. These are the three most common acronyms and names that are used. There are others. Sometimes it's just called the Architectural Committee, the AC. Sometimes it's called Design Review and Architectural Committee, the DRAC. So you will just see all kinds of different names. It's going to be defined in your documents, whatever it is, but they essentially all mean the same thing. It is a committee of the association that is designed and set up and established to handle all things architectural in the community that you live in. Today, I'll probably use ARC. That's the most easy way for me to describe it. It rolls off my tongue the best. So I'll call it ARC for today's purposes, but understand it means any of those. What purpose does an ARC serve? Well, first purpose is to protect the aesthetics, right? You want to make sure that the exterior of a home or a lot or a condominium building looks good. Curb appeal, it helps resale value. It handles the ability of the community to put its best foot forward and presentation forward so that when people see it, they want to buy there and they want to live there. And so first purpose is to protect aesthetics. It's also there to control the quality of materials, the construction that's being done. That comes in many different shapes and sizes. It may be setbacks and adhering to setback requirements. It may be the standard that your community has in terms of what gets put on a roof, type of roofing, or the exterior cladding on a building, type of paint, how long the paint lasts, so that you don't have problems with paint peeling and so forth. Many different things, but the design of an ARC in the governing documents is to protect the quality of materials and construction. So just love this picture. If there are any Boise State fans here, I apologize, but that's a pretty garish looking house. And this is precisely what an architectural review committee is designed to help protect against, a house like this. All right, where do you find your ARC provisions? Well, they're going to be in your governing documents. They're going to be in your declaration. They may also be in your bylaws, particularly for those condos. And then some associations, actually, frankly, those that that are most organized and that have the most experience with this, will have an architectural manual and guidelines. And most associations, I'll be honest, don't have architectural manual and guidelines, and they should have them. But those that do a lot of architectural review on a consistent basis realize that you cannot live without an architectural manual or a set of guidelines that the ARC lives by.
Chris,
Chris? Yes.
We're still on the title page.
Oh, you're not seeing the
well, we see the presentation, but we're still on the title page, on the VF page. Can you were mentioning the house, you were talking about a specific house, so I think you should be on like slide 5 maybe.
Yeah, let's
I think you need to put it into slideshow mode.
well, it is on my laptop. The problem is I have 2 screens, so I'm seeing it in slideshow. on my second screen.
Drag it over to your other screen if you're able to.
There you go.
All right, is that working?
Yes.
Yep.
Okay, all right. My apologies, everybody. Okay, so there's the names: ACC, ARC, DRC. Of course, the purpose of the ARC serve, and then there's my Boise State House. Okay, there we go. Okay, so where do we find them? Deck, bylaws, architectural manual, guidelines, and then the power and authority is granted by your documents. Now, this is important because, and this is a lesson I learned very early in my legal career as a young new baby attorney. The documents control how an architectural review committee is set up and where the authority lies. So, for example, some documents give the architectural review committee autonomous control over all architectural review issues. There is no appeal right. There is no input from the board. It's rare, but they are out there. Sometimes the documents, in fact, frequently, and when we set them up, this is how we do it. There is always an appeal right from an ARC decision to the board. And then the documents also are going to describe how the committee's set up, how members are elected, how long they serve, how many committee members there are. All things like that are going to be found in your governing documents. Now, let's talk briefly about condos. For those of you that live in condos, your architectural review is likely going to be much, much smaller because of the type of ownership. Of course, in a condo, the common elements under Oregon law are owned in common as essentially tenants in common, meaning that all of you have an undivided interest in the common elements. Sometimes it's based on square footage and you have a percentage based on your square footage. Other times it's equal, but the ownership is not in the name of the HOA, it's in the undivided interest of all of the unit owners. So while the Condo Act does not specifically talk about architectural review and set out the process, it does have one section that talks a little bit about alterations to a unit. And here you see ORS Chapter 100, Section 535, which says, subject to the governing documents, an owner cannot make an alteration to a unit that impairs the structural integrity of the condominium. And it goes on to say that if you want to make an alteration that does that, you have to get board approval. This language is often parroted in condominium governing documents. Most developer lawyers will cut and paste this language and put it in there. So that's the statutory basis for a condo. Now, the board has 45 days from the application to approve the alterations and allow that to be done or to deny it. And that's also statutorily based. Now, the Condo Act does give the board power to require a unit owner to have experts come in and submit their opinion on the impact of the work. And these are experts hired by the association, they're hired by the owner, but the association may also hire its own expert if they don't like the opinion from the owner's expert. And they can make the owner obviously pay for the cost of this. And then, of course, the standard language here in the middle bullet item, which is that owners cannot change the exterior appearance of the common elements without prior board approval. And so what a lot of people don't understand is that includes the grounds. A lot of times landscaping gets changed. People go in and want to plant their own rhododendron or their own other flowers and in these common element garden beds or flower beds outside the exterior of a building, and they are not allowed to do that. So they've got to get board approval first, and that frequently doesn't happen. But the Condo Act gives the association that protection. It also, of course, deals with things like you can't paint the exterior of a condo unit or the building on your own, can't paint the railings. This applies to any common element, whether it's a general common element or a limited common element. It's, again, got to have board approval. And then lastly, the last bullet point, again, deferring to the governing documents first, but it says that if a unit has to be maintained or repaired or replaced, that's the responsibility of the unit owner, not the HOA. Now that just as an aside here, we're not here talking about insurance, but insurance is a different beast. This is your garden variety maintenance, repair, and replacement of items inside the unit that it's talking about here. All right, I'm skipping through condos pretty quickly, in part because condos often do not have the same number of applications or opportunities for architectural review that a planned community has, a planned unit development, and frankly, townhomes as well,
Sorry to
even though
interrupt.
townhomes are like condos.
We have someone in the waiting room. If you could please let them in.
Yeah, I got it. Thank you.
Thank you.
So planned communities governed by ORS Chapter 94. The Planned Community Act talks about owners having the right to repair, restore improvements on a lot in the event of damage or destruction. Of course, that's targeted mainly at insurance, but it deals with architectural review as well, because if a property is totally destroyed, then the architectural review committee is likely going to have to get involved, particularly if there are going to be changes from the original design of the building or the colors or the materials. It also provides that architectural controls and review of plans of a structure may be included in the declaration, and most of you have that in your declarations, where it governs the architectural review and the process that is followed in order to handle that architectural review for the community. So what then is that review process, and where is that contained? Well, as you can see, the statutes, neither the Condo Act nor the Planned Community Act, really have much concerning architectural review. It's always going to be found in your governing documents. Now, this is a typical ARC provision. Yours may be different, but this is pretty standard. Sometimes we lawyers are not an original sort, and a lot of times these architectural review provisions get plagiarized from one set of documents to another, and they tend to all be pretty similar. So this is the standard one. It says no improvement shall be commenced, erected, placed, or altered on any lot until the construction plans and specifications showing the nature, shape, height, materials, colors, and proposed location of the improvement have been submitted and approved in writing by the Architectural Review Committee. It is the intent and purpose of this declaration to assure quality of workmanship and materials and to assure harmony of external design with existing improvements, and as to location with respect to topography and finished grade elevations and compliance with setback requirements. So notice, first of all, that the word improvement in the first line is capitalized. This is not a typo. Frequently, improvement is a defined term in governing documents, particularly in a set of documents for a planned community. And improvement, when it's defined, often includes anything that is not dirt. It includes structures, it includes fences, it includes retaining walls, it often includes landscaping. So improvement is typically defined very broadly, and that's something that you would need to look at in your documents. But the intent behind it is that nothing can be done or altered or built or erected or set upon or placed on a lot without first going through the Architectural Review Committee. Now, A lot of people may disagree with that policy. Board members may disagree with the policy. They may say that takes too much time. It's not worth it. It's not of benefit to us. It's too burdensome. But the reality is its design and its purpose is to provide that oversight and protection for the aesthetic look and the material and construction quality of a property. It's also to ensure timeliness of getting the work done so that you don't have somebody start a project and then run out of money midstream and not be able to finish it. There are protections in there for that. So this is the typical provision. Yours will likely have many of the same components or similar language as to what is allowed. Now, the other thing I want to talk briefly about is the second half of this ARC provision, where it talks about the intent and purpose of this declaration to ensure quality of workmanship materials, to ensure harmony of external design with existing improvements, and as to location with respect to topography and finished grade elevations and compliance with setbacks. So this provision, if you notice, we kind of cut it short. I didn't want to give you the whole provision because there's more in the middle, but it alludes at the end there to various factors that the ARC is supposed to consider when looking at things. Typically, it will have language that says something like the ARC can consider several factors, including harmony with external design of existing improvements, location, topography, view, all these different things that can be taken into account by the Architectural Review Committee when looking at it. And those standards are real. It's what the ARC should be looking at and taking into account. Now, that doesn't mean the ARC has to take every single factor into account in every single case, because they may not all apply. For example, if I am changing the paint color on my house, the topography and finished grade elevations in compliance with the setback requirements are not going to apply to my changing my paint from brown to a green. But there are other factors that will apply, like how it looks in comparison to everything else that's out there. And so the ARC needs to consider these. It needs to look at them, and then when it issues its decision, a good ARC will state which factors they have considered and how they view them to apply. Now, I realize that sounds very formal, but if you don't follow the formalities, then you're going to end up in trouble. And let me give you an example on a good side where the HOA was very formal. I represent an association that within the last 3 years was in litigation over a retaining wall and a fence. And they have a provision kind of like this one that says you can't do anything without prior Architectural Review Committee approval. So they had a homeowner who came to them and said, hey, look, I want to, he filled out the ARC form that they had, their standard ARC form, and he said, I want to extend the fence along the side of my house to the northern boundary of the house. And then I also want to, I need to do some landscaping work to make the fence level with the house. And that's what he put on there. So my board president, he went out and he met with the gentleman on site, and they talked about it, and he came to understand what the gentleman's purpose was and why he wanted to do it. And part of the reason he wanted to do it is there are 2 windows on that side of the house that were open to the street, because the street came winding around the side. These 2 windows face that street, and they happen to be his children's bedrooms. And so he wanted some more privacy and protection for his young children. And so he wanted to extend the fence all the way the length of the side of that house. Then to level it and get it set, he needed to do some landscaping. So the board president, in this case, in this community, the board also acted as the architectural review committee. The board president said, yeah, that's fine. That's good. And so he approved it. And on the approval, he wrote, go ahead and do it, but you got to comply with the county, and you've got to apply to, you got to follow the CC&R requirements. So you got to satisfy the county's requirements, and you got to follow the CC&R requirements. And then there was something else, like you have to, paint has to match the existing fence. So you can't paint in different colors. If you're going to paint and you replace part of the fence or extend part of it, then you got to paint it all so it looks good. So the approval's given, the guy starts work, and it became readily apparent very quickly that the work that he started was not the work that he got the approval for. What he ended up doing is he tore down the existing fence. He moved the fence 10 to 15 feet closer to the roadway. He brought in a ton of block and began building a retaining wall around the front of his house, which was the northern boundary, and wound it around to the side. And the property sloped down. So it sloped to the southeast. And so as he extended the fence and brought it around, the retaining wall kept getting higher and the fence kept getting higher because of the grade of the property. And so he essentially finishes it. He builds this retaining wall, sticks a fence on top of it. They had a requirement the fences only be 6 feet high. Well, by the time you had a 3-foot retaining wall, it's now a 9-foot fence. And so this is going on, and the HOA goes out and says, stop, you can't do this. What are you doing? This is not what we approved. And he said, sure it is. I wanted to extend the fence. I've done that, and I need to do some landscaping, and that's what I'm doing. I have this retaining wall, and I'm leveling the fence and doing this landscaping. Long story short, the HOA sent him a bunch of letters, demanded that he stop, demanded that he submit a second architectural review application to accurately reflect what his project was going to be, not what he had told previously. So he did submit a second one. They looked at it. They considered other fences in the community that may be on retaining walls and other things, and ultimately declined to allow him to do this and told him to stop. And he stopped, and he didn't finish the whole thing, although most of it was done. But he wouldn't tear it down. So they ended up suing the guy, to seeking a court order requiring that he tear it down. And this is where I got involved. So I got involved in the lawsuit and ended up going to court. We got a judge to rule in our favor that he did not comply with the approval or with the governing documents, and he needed to tear it down. We then asked for our attorney fees. At this point, the association had spent approximately $50,000 in attorney fees between the initial work before litigation was started, where the attorney was involved in dealing with the notices and getting him to take it down, and then later on the litigation side. And the judge awarded almost all of that. There were a couple $1,000s that she didn't award, but essentially awarded all of it to the HOA. Well, then, to make matters worse, the guy appealed, and he appealed to the state Supreme Court. This was not here in Oregon, it's in one of Oregon's neighbors, but he appealed to the Supreme Court, and then I had to go argue this case to the Supreme Court. And in the course of looking at it, the Supreme Court issued its decision in favor of the HOA. And one of the bases that they ruled in favor of the HOA was that the HOA, when it made its decision, had looked at these various factors, had taken them into account, had identified which factors they were looking at and which factors they were not, said why they went that route, and then ruled the way it did. And the court said they did exactly what they were supposed to do. They followed the process, and this is what an architectural review committee is set up for, and this is what an HOA is set up for. And the attorney on the other side, the homeowner's attorney, was arguing all of these policy reasons. It's not fair, it's not appropriate, it's an excess of power, it's not harming the community, it looks good. And frankly, you know, it didn't look horrible, other than you had this fence that was in violation of CC&Rs in a number of ways, a height restriction, how close it was to the street. There was a covenant that prohibited that, and a number of other things. And the Supreme Court said, nope, you can't have it, you got to tear it down. And then we went to the Supreme Court and said, okay, this is how much the appeal has cost us in attorney fees, we want it, and they gave it all to us. So at the end of the day, the HOA got an award of attorney fees, so it got almost all of its money back in dealing with it. But it was a very expensive process, in part because he appealed it to the Supreme Court. But it wasn't an expensive process, and we'll get to enforcement later, and we'll talk a little bit more about that. And I know that scares some associations from doing anything. But the point here that I wanted to make is that when you are looking at those factors, use them. Don't just think they're nice little words used in the governing documents that really don't have any practical effect or meaning. They do have practical effect, and courts look at them and they make sure that you are following them and not just making an arbitrary decision based on the taste of the day. You've got to actually look at this and consider these things. All right, now, the typical process. Most of your documents are this way. You may have different wording or a different process, so you need to look at your governing documents, but this is typically the way it is. Committee members are nominated by the board, and they often serve on a 1 or a 2 year appointment. And typically the documents say that they can be appointed at the whim of the board, and they can be removed at the whim of the board at the sole discretion. So it's going to talk about how they're appointed and how long their terms are. Now, it's also often going to talk about the process for an owner making an application. They have to make a written application to committee. Often it will say you've got to have something like all plans, specifications, and anything else, you know, paint chips, material samples, things like that have to be included. And then it says, if you don't submit all of that, the ARC can request more information or ask for clarification. So the owner makes the application to the committee. I know that a lot of management companies and a lot of self-managed associations, particularly those that do a lot of this work, have a form that they use or a couple of forms that they use with things that need to be submitted, and that's fine. You can have an application form, but you need to make clear that the application form doesn't replace all of the other things that you are required to have. The elevation drawings, the footprint drawings, any landscaping plan, any screening plans, paint samples, product samples, a topography site plan with the gradation shown on it. If you're doing some engineering that needs to happen, an engineer's report, things like that, or a geotech report if you're changing the grading and dealing with that. All of those need to be included. So you need to be aware that an application, and again, this is based on your community and what is allowed and what's there, but you need to understand that sometimes your single page written application is not enough, that you need other things, or that you need to require owners to submit other things, and your application should account for that. It should reference that and state that. Your documents also typically have a time period by which the ARC must respond. Most of the time, there is a provision that says if they submit it and you don't respond by written denial within this period of time, and again, that's usually 30 to 45 days, that's the standard. then it is deemed approved. And I'm not a fan of those because far too often I deal with ARCs that are not that organized or boards that are not that organized, and the time passes and then they come and say, wait, they're doing this, can we stop it? And the answer to that is no. If you don't respond in time, then by the plain language of the documents, it's deemed approved. But other sets of governing documents will have this time period in, but it will not have the follow-up clause which says if you don't respond within that time, then you don't automatically have approval. There may be other remedies, but approval is not automatic. So you need to look and see what your documents say. If it does have that tight time frame where approval is automatic, if you don't give a written denial, then you need to stay within those timeframes. I've had a few cases over the years that have gone to court or mediation just before court, where we've had to fight over this automatic approval. And part of the confusion that often comes is if the application does not include everything that the board wants or the ARC wants in there or is required to include, and does that affect the time and extend the time? And it often does, but you got to be clear. And this is where your guidelines and your processes need to be clear. And oftentimes the governing documents written at a high level are not as clear in that process. And so you need some additional rules and architectural guidelines that lead people through that. Now, our committee then reviews the application and issues a written approval or denial. Sometimes the approval is a conditional approval where they have to do certain things either prior to starting the work or as part of the work process. There may be certain stipulations. The denial, it can come in different forms. It can be a straight denial, but the best denials are those with suggestions or reasons. And as I discussed in my prior example, tying those reasons to the factors that the ARC has to consider. That's always the greatest protection. When you say, look, we didn't approve it because the way it was set up, it didn't fit within the height restriction of the property, and it exceeded it by 2 feet, and here's where we base that on, and so we're denying. Those are always better than we're just denying, hit the stamp, deny it on it, and send it back. Those are never as good. Now, quick little aside here before I get to an appeal. As I mentioned earlier in my example, the Architectural Review Committee was the board, and most of you have documents that say if there is not an independent or separate Architectural Review Committee appointed, then the board can act as the Architectural Review Committee. And that's fine. Sometimes it may not be separate, but you have a number of board members who are also serving on the Architectural Review Committee in addition to the board. And so the important thing to remember here is that if you have an Architectural Review Committee that consists of board members, then you need to ensure that you don't have a quorum of the board on the committee. Because if you have a quorum of the board on the committee, then whenever the committee meets, that's a board meeting under Oregon law, which means you have to give notice and you have to invite all of the homeowners. Most of the time in your documents, ARC committee meetings are not required to be open to the homeowners. Now, we're not going to debate whether that's good or bad today. That's a policy issue. But the fact of the matter is, most of the time, your ARC meetings, your committee meetings are not required to be open to homeowners. But if you have a quorum of the board serving on the ARC, let's say you have 3 directors and 2 of them also serve on the ARC, well, now you have a quorum. And that means that you have to go through the open meeting requirements of Oregon law, which includes sending out the notice and allowing owners to attend. So that's why it's best, if you are going to have any directors on the also on the Architectural Review Committee, that you only have one or fewer than a quorum if you have a larger board, larger than just three directors. If you have a 5 or a 7 or a 9-person board, then you can have a couple of people on there, but always make sure that that number is less than a quorum. All right, now what happens if the ARC denies the request and an owner's unhappy? Well, I am in favor of appellate rights. I am always a fan of allowing an appeal to the board. I just think that it looks better, it plays better, it ensures due process, it hopefully eliminates some of the biases and the self-dealing that just arise in architectural review. Now, I admit that this can be difficult, particularly if your board is also the ARC. There's not really much of an appeal right. You can have them, you can rehear it, but it's not likely to change. But I am a fan of appellate rights to the board. And when I do amendments that deal with architectural review and they don't have this language in their documents, I encourage my associations to amend that and add the appellate right. There may be, if your documents are silent on whether there's an appellate right or not, I think by rule that the board can say, we're going to allow an appellate right, unless there's something in the documents that specifically say, no, you can't do this, or the Architectural Review Committee's authority is autonomous from the board, which brings me to the note here in this one, the Little Whale Cove case. Little Whale Cove is a big association. It's been around for decades over on the Oregon coast. And this is just a highlight of what I alluded to earlier in the presentation, that some architectural review committees have complete autonomy from the board. And your documents are going to say that, they're gonna specify that. And if that's the case, then you can't have an appeal to the board because the board has no authority. But that's driven by specific language. And if you have questions about it, I would suggest that you get an attorney's opinion on it to see what he or she thinks about it, and see what the authority is. So if it's an issue for you, feel free to contact me or one of my colleagues. But for most associations, it's not an issue and you can have an appeal, and I would encourage you to do that as part of your architectural guidelines. Now, having said that, I am going through this very issue with an association in Vancouver right now, and they have very detailed guidelines. It's like 7 or 8 pages of architectural guidelines beyond what is included in their deck and bylaws. And they talk about a number of different things. And in that case, I think sometimes they're too detailed. And I think in some cases they're not detailed enough. But one of the things that they do outline is an appellate process to the board. And it's a very good process. And the board made a decision, and they included in their guidelines a provision that after the board makes a decision, you can request that the board's decision go to mediation. The intent is that before there's a lawsuit filed, the unhappy party has to offer to use mediation, which makes sense. If you can avoid the cost of litigation, great. But the problem is the way they set it up, it's mandatory and it's creating all kinds of havoc for us. So as you're drafting guidelines, you need to be smart in the requirements that you put in, and without trying to sound too self-serving here, this is probably something that as you're drafting those, either have your lawyer draft them for you, or you work with your lawyer to make sure that what you're doing in there doesn't have unintended consequences that you don't want to create additional problems, additional steps, additional costs for the association as you're going through this appellate process, because it really can come back to bite you. This mediation clause, I was not involved in drafting the guidelines, and I was not involved in this another case that they had, but they had another case that went all through the process. ARC made a decision, got appealed to the board made a decision, the owners asked for mediation, and $4,000 or $5,000 later, the association had gone through this, and they reached the same decision. They weren't able to settle it in mediation, and it was a waste of money. And so, sometimes even the best laid plans don't work out. And so as you look at drafting guidelines, I would encourage you to consult with your attorney and see about some of these things to make sure you don't have unintended consequences in what you're setting up. All right, switching subjects a little bit. Again, it's a process, but it goes more to the how. How are the decisions made? We talked about this first bullet point already quite a bit, but you're looking at the governing documents, you're looking at guidelines and standards that you have in place, and you follow them, and the ARC makes the decision. Now, this can come in various size, shapes, colors, and ways. So some associations, as I mentioned earlier, have guidelines that specify the materials that are allowed. A presidential TL 40-year composition roof in black or gray color, and it's very specific. It might say cedar shake shingles or composite but no tile shingles. It might say you can have lap siding from Certainteed or Hardy, but not from Louisiana Pacific. There are a number of different ways that this gets spelled out, but they're spelled out in the guidelines and it's very clear. Other associations are not that specific. They say before they just have a general catch-all that says before you make any change, you bring it to the ARC and they will tell you if it's allowed. The problem with the latter is that it often leads to inconsistent results. It often leads to the taste of the Architectural Review Committee members or the board members at the time. Now, I acknowledge that even if you draft specific guidelines that a subsequent board or a subsequent Architectural Review Committee, whoever makes that decision, that comes along, they can change them and say, yeah, we're changing this, we're not going to allow that, or we are going to allow this. That is true, that can happen. But I will tell you that in those areas where you can be more specific, you're better off being more specific. Because if you're not specific, then you run into all kinds of problems of unequal enforcement, discrimination, all those things that create headaches later on. And maybe it's you come up with a paint color palette. Maybe you even specify the painting stores that you can get it from. Benjamin Moore, Sherwin-Williams, whatever it is, and it's the nature palette that has this green and this yellow. Maybe you have the paint numbers, but you specify so that there is no question. And then if somebody wants an exception from that, you can consider it, but you can also easily say, no, we're not going to allow it because we have made the decision that we're only going to allow these paint colors. And if you do that, and if you do that consistently in terms of how you apply those standards, then you're going to be fine. Now, the caution here, and the important caution, you cannot in your architectural guidelines or standards contradict or go against what is contained in your governing documents, because in hierarchy, your declaration restrictions and your bylaw provisions are higher in authority than your architectural guidelines or your architectural rules. So, for example, if the governing documents say you cannot have pink houses, the ARC cannot come along and say, well, we'll allow a mauve or an off pink or a rose color house. That's okay in our palette. The ARC doesn't have the authority. The board doesn't have the authority to do that because of the specific restriction in your governing documents. On the other hand, if there is no specific restriction, the ARC has the authority to fill in the blanks, to fill in the gaps. And typically, the language in the architectural review section or article of your declaration will have general language that says something like, the Architectural Review Committee may establish standards, guidelines, and rules governing these things. And that broad grant of authority allows you, within the confines of your governing documents, to establish rules and to establish standards. Now, this is, of course, very important when a community is under new construction, but it's overlooked far too frequently in a community that's already built out. People will say, well, why do you have these guidelines? We're already built out. The only thing that's happening is a remodel. And the answer to that is that's not true. Homes in these communities burn down. They fall into disrepair from rot or other problems, and they have to be rebuilt. And so having a standard that runs for a full length of time, or it may get updated and changed periodically, but is there in place, protects you when something goes wrong. It protects you when the house burns down. It protects you when a big, large-scale remodel that impacts the exterior is being done. Far too often, HOAs are caught unprepared and unaware and ready to deal with it. And so you need to get these in place to ensure the protection when the time comes. All right, what's the legal standard? The legal standard is generally fraud, bad faith, or failure to exercise honest judgment. That comes from a case out of Bend called Valenti v. Hopkins. But fraud, bad faith, or failure to exercise honest judgment can come when you're making arbitrary decisions. This goes back to when you're making decisions, tie it to the standards, tie it to the factors that are contained in your governing documents. Also, do you allow the owner to be present at the meeting? Most of the time, documents are silent. I am a fan of that. I think that the owner making the request ought to be able to be there, ought to be able to participate and ask questions. I know a lot of people don't like that. Oh, they'll be loud, they'll be unruly. If we deny it, they'll be upset and angry and threaten us, whatever. I get all that. I still think that you're better off allowing the owner to be present. It's a due process issue. It takes away the whole secrecy piece of it. Allow them to be there, but that's something that is set up in your guidelines, and if it's not already contained in your governing documents. Do the decisions have to be made in an open meeting? Again, your governing documents are going to specify, obviously, again, if you have a quorum of the board, yes, it must be in an open meeting. But if you don't have a quorum of the board serving on the Architectural Review Committee, then most of the time the answer to that is no. It does not have to be an open meeting. I prefer to let it be the ARC and the owner and any of the owner's experts or attorney or whoever they have there helping them out. Okay, we've talked a little bit about your governing documents and the standards. Remember, that's what you need to follow. The rule is very clear. You got to follow what's there and follow it to a T. Procedures, we've also talked about the application, the time for decision. We didn't talk about follow-up, but most of your documents will say if they have times, they frequently have times when the work must be completed by. Landscaping is frequently 6 months to a year. Other times it might be for work, it might be 90 days, it might be 6 months. Most common is a year from approval. And it gives the ARC the ability to go in and inspect, to recommend that the board take action, or sometimes for the ARC to take action and levying fines, go to court, etc. It's all going to be specified by your documents. So when there is a violation, what can you do? Well, you can fine. You can sometimes self-help, abate the violation. That self-help is especially true in a condo where people are doing things to the exterior of the building or planting in the flower beds. That's when they're doing, because at that point it's essentially association property. Legal action, so you can go to court and get an injunction. or damages. The injunctive relief is the example I gave about that stupid fence and retaining wall case. That's my name for it, the stupid fence and retaining wall case, because that's what it was. But we sought injunctive relief, and we didn't seek damages, but we did seek our attorney fees and costs. Meetings. So if it's required to be in an open meeting, that could be a violation as well. But that cuts the other way, and we need to be careful and know what that is. All right, so enforcement. When an owner is starting to build something that clearly violates the rules, so this is my retaining wall and fence case, what do? Well, you have to know your documents and you have to follow them. And if you don't know them beforehand, then you're already behind the 8 ball. You're late if you have to try to get caught up. You need to know your documents, you need to follow them. Are they violating a rule, a covenant, a provision? Did they have to ask permission first before they did it? You need to know all that. You need to know what you can do and where they are. Pre-litigation, meaning before a lawsuit is filed, you can try to resolve it in neighborly, informally. Again, the court, in my case, said the HOA did a great job of this. They went over and they did it and they tried to resolve it informally in a very neighborly way. Then they asked him to submit a second architectural review application, and they issued a written denial, and they gave the bases for the denial. They sent a cease and desist letter to get him to stop work. And they didn't fine, but they could have fined and levied fines. And I think the court would have been okay with that in that case if they had done that. Remember with fines, the VF Jiffy Lube rule, 3 months or $3,000. Fines are designed to deter bad behavior. They're designed to get people to either stop doing something that they shouldn't be doing or to start doing something that they haven't been doing. And if this goes on for 3 months or $3,000 or more, then fines aren't working and you need to move to something else. In my case that I was telling you about earlier, the court found that, they worked with the homeowner for 6 or 7 months before they filed suit, before they started the litigation. The court felt that was fine. They didn't wait too long. They tried to genuinely go through the process, but eventually they said they had to move on, and that's what they did. And the court was in approval of that. All right, questions for litigation. When do you have to call a lawyer? Well, once there's a threat of a lawsuit, or once you start getting wind that the work's being done inappropriately, even if the other side doesn't have a lawyer, even if the homeowner doesn't have a lawyer. The earlier, the better. Do we let them sue? Do we sue them or let them sue us? There are situations where either or can apply, but frankly, if you're trying to get them to stop work, you're going to need to sue them. A TRO, a temporary restraining order, versus a preliminary injunction or mandatory injunction. These are different types of relief. Temporary restraining order you may sometimes have to get, but they are frankly the most expensive work that can be done in the law, because you're essentially trying to go to a trial within a short order. It's like 14 days. And so there's a lot of legal work, a lot of costs associated with that. And they're limited in duration. They typically only last 10 days or so, sometimes 14 days, but it's expensive. Most of the time what you're seeking is a preliminary injunction that buys you a little more time. And then at the end, the preliminary injunction turns into a mandatory injunction or permanent injunction. Insurance, if we get sued in all this, what does it cover? Typically it covers it. Your directors and officers insurance will typically cover it and give you protection if the homeowner sues, or if you file a suit and they countersue back, your D&O carrier will cover it. But you need to ask your broker if you have that coverage, if there is an issue. All right, quickly in the last few minutes we have left, what are some frequent ARC issues? Well, failure to enforce is often an issue that I get called in to help clean up. There are some defenses that get made all the time. Estoppel is you can't do this because you don't have good hands. You've allowed it somewhere else to do it. You're prevented from doing it, or you allowed it, so now you can't come back and enforce it. Those are all variations of estoppel. latches is a "you've waited too long" doctrine. We did this 5 years ago, and now you're just bringing it up. You've waited too long. That's the doctrine of latches. Waiver is you waived it based on time. That's where the 30 or 45-day time requirement piece comes in. It also might be you waived the covenant because you've allowed a number of other properties to do this, and now you can't come back against us. What I found is a lot of documents have an anti-waiver clause that says it doesn't matter if we haven't enforced this previously. We are still allowed to enforce it now, and there is a process for reinvigorating your enforcement ability. Violations in progress are always a little tricky because you want to allow them to cure, but you also don't want to wait too long. So how do you deal with that? I'm a fan, you know, and I say this without making it, again, trying to sound too self-serving, but you're always better off filing suit earlier than later. Filing later always creates some problems. Now, can we wait a couple months, a few months? Yes. But if violations are in progress and you know it and they get it built, that's a big issue because courts are loath to tear down a roof or tear down a structure that's already complete. They'd prefer to give you damages, money damages in lieu of tearing it down. So if a violation's in progress, I'm going to tell you, file suit now. We got to stop it. Unauthorized approval. So I actually just dealt with this down in Southern Oregon. I had a case where I was dealing with this very issue where the board president communicated to the other side that they could install a shed, but the architectural review committee and the board did not approve the shed. The president was acting allegedly on his own. And then I had to come in and help clean up the mess, and it was an unauthorized approval. So we had to deal with that. And so you need to make clear what the board president or the architectural review committee chair's role is in all of this and the authority that she or he has as they deal with it. All right, quickly, political signs. This is a hot button issue, but this is often governed by your ARC because it's arguably an improvement on the property. There is legislation that impacts this. A number of states are passing it. It's a hot button issue, but you need to be aware of it. Height restrictions, another common issue. You know, what's allowed, what's not allowed. A lot of neighborhoods say 2-story, but not more than 2-story. They might have a height from the lowest grade. So you need to be aware of that and follow that. And often this is where you need to actually pony up and bring somebody in to measure and to be an expert on it. Another problem that associations have is they try to do this on the cheap. No offense, but many associations do. And if you're going to do it and you're going to do it right, you got to bring in the experts to guide you, whether it's an engineer, a surveyor, a geotech. You need to bring them in to help you sort through that and sort it out. View obstructions, that's a big issue, dealing with this all the time. It is, you know, largely driven by what's in your documents, but it is an architectural issue that blows up faster than just about anything because people want their views. And if the neighbors aren't giving them their views, they're coming and asking for help. And this one seems to be the most contentious of essentially all of them, whether it's plant life, a tree, a shrub, whatever that's blocking the view, or a building. It's a hot button issue. Flags are another issue. We have the Freedom to Display the Flag Act. So this covers the American flag. It covers flag poles. The board is allowed to have reasonable time, place, and manner requirements, and there is a limitation on size, but there are sticky wickets with flags. So if you are looking at implementing some flag restrictions in your guidelines and your documents are silent on that, consult with the lawyer. Make sure that you're not stepping into something that you don't want to step into and create bigger problems for yourself. Satellite dishes, OTAR, the over-the-air reception devices rule, which is set by the FCC as part of the Federal Telecommunications Act. This allows owners to install satellite dishes on property that is in their exclusive use and control. And so it essentially gives me a constitutional right to my DirecTV, my NFL Sunday ticket. It relates to the DirecTV and Dish Network size dishes. It's not a huge dish like the one in the picture. There is a size requirement, but it also deals with internet and other antennas that are allowed, or over-the-air antennas for people that want to just use an antenna as opposed to a satellite dish. All of it's covered by OTARD. There are limitations on what the board can do. Most of the time for a condo, it's not as applicable because they want to install it on area that is not their exclusive use and control, like the roof or the side of the building through the siding, and the HOA can prohibit that. But if they want to do it on like a limited common element patio or a deck, then the condo association cannot prohibit that. That is their area. For those of you in PUDs, I think it's a really difficult fight. If you wanna really pick this battle, talk to legal counsel to make sure that you're on solid footing, because I'll tell you, my opinion is, if I own the dirt and I own the building, I don't care if you're maintaining or insuring it. It's my exclusive use and control. I think that's how the Department of Justice and the FCC would interpret it. And I'm allowed to have a satellite dish no matter what. Now, I may be required to pay for damages caused by that dish if I poke through a roof or a siding that the HOA maintains. But because I own it, particularly in townhome projects that are not condos, because I own it, I can do whatever I want there. So that's OTARD. Fences is another big one. Be aware of what your fence rules are. Be aware of what the county restrictions are. Often it's a 6-foot fence, but sometimes there are exceptions to that. So be very clear in your guidelines. Materials as well: wood allowed, vinyl allowed. What about barbed wire? What are you allowing in terms of fences? Also, be clear on what goes on top of the fence, because a lot of times they'll say that the things on top of the fence are not part of the fence, and you don't want to have to argue that if they have things that you don't want on top, whether it's lighting or lattice work, whatever it is. Make sure that you're clear in all of that. And then outhouses and other improvements. This is often language that you'll see in the documents, including the definition of improvement, like we talked about earlier. It will have something like outhouses or other improvements. Well, in your guidelines, define what some of those improvements are. Give some examples. Make it clear so that it's clear that you can deal with it. Finally, yard decorations and lawn ornaments. We have a famous case in our office. It was not mine, but it was one of my partners. Had a gnome case, and it was out of I want to say Eugene or Albany or Springfield, somewhere down there. And this homeowner had a jillion gnomes and other lawn ornaments that made the yard look pretty bad. And so these are improvements. They're things that you can regulate and should regulate. A lot of times people will say, well, that's too much of the nitty gritty. We don't want to delve into that. That's fine. Just remember, sometimes that nitty gritty comes back to bite you if you don't establish a guideline on the front end. And then you get the home like we had down in Eugene or Springfield that had a few hundred lawn gnomes throughout that we had to then try to go back and deal with. All right. We ran through a lot. I shot a lot from a fire hose, and we've run the course of our hour, but I'm certainly willing to stick around for a few minutes and answer any questions.